started.
I'll call the meeting to order at 1:04. Roll call, everyone is present. The meeting was properly announced. I will open up now for nominations for chair.
Nominate Mr. Zabarski.
I don't know whether I could
No.
do that.
It's
Oh,
gotta be
oh.
somebody on the
Oh.
board.
Yes, if you could please read through the checklist of the board members.
Ken Bork, Jerry Paler, Tom Krog, Terry Fahrenkrog, Kelly Olson.
And all are present.
All are
Yes.
present.
Mr. Crowe.
I would
Okay.
second that nomination.
I'm fine. I would nominate Terry to be the chair. He was the chair last time, did a good job.
Are there any other nominations? Are there any other nominations? Are there any other nominations? Okay, I'll close the nominations. Mr. Croak does not wish to be chair, so we won't vote on that. All in favor for Terry Fahrenkrug, raise your hand.
Aye.
4, 5, yes? Okay, Terry will be the chair, and I will appoint Kelly Olson as recording secretary. So with that, I will turn the meeting over to Terry and excuse myself.
Okay, entertain a motion to approve the agenda.
So moved.
I'll second that.
Okay, I need you guys to make sure you go slow enough that I can keep this.
Gotcha.
So who made the motion?
Mr. Cook made the motion. Second by Mr. Paler. All those in favor?
Aye.
Opposed? Agenda's approved. I'll entertain a motion to go into closed session for Wisconsin statute 19.85.
If I could.
Sure.
My name is Jim Kalny. I was retained by the Corporation Counsel's office to represent the board in this matter. I know that the agenda suggests a closed session. More importantly, it says that we're going to have the initial review hearing and determination of what jurisdiction and basis, if any, exists for the ethics complaint filed alleging violation of Adams County ethics ordinance against elected officials pursuant to the sections that are listed in the agenda. I understand that the individual involved would prefer this matter to be in open session. And frankly, if that's the case, 19.85 sub 1 sub F is a provision that has to do with when there is a matter that substantially would adversely affect the reputation of the individual involved. So it really is a reputational interest that goes to the person that you'd be discussing in closed session. Also, I just want to emphasize that this is a very limited purpose hearing. There's not a lot of things we do here today. I'll explain that a little further. I would suggest we simply proceed in open session on this matter. Transparency is best, and I think our reason for going into closed session, particularly with the request of the respondents that we don't, is kind of weak, and I don't want to see us getting in trouble in that regard. And I don't think there is anything we're going to be discussing today that's going to be damaging to anybody's reputation.
Tori, both of the respondents agreeable to that open session?
We requested it.
Or you did? Okay. Ms. Demo, you as well?
And the record should reflect it's being taped. I'm assuming I'm talking to Ms. Demo and Ms. Juan. And you both would prefer actually that it be an open session. You're not
Yes.
requesting this to be in closed. I really don't think it's a good idea to go in closed session in any case.
Mr. Kowarski, you're agreeable to that as well?
I have no opinion. Doesn't really matter to me.
Any objections from the board? Opening an open session.
No objection from me?
Do we need a formal motion?
No, because it's noticed that that's the item on the agenda. It's just we're not going into closed session. You always have the option of not. And Mr. Chairman, if I may, I'd just like to address the board on a couple matters before we get started. As I said, this is a kind of unusual hearing, this initial hearing under your ordinances. I took the liberty of copying chapter 34, our ethics code. You probably all have it at home, but we're probably going to have to refer to this a little bit today. So I wanted everyone to have a copy of it. I also took the liberty of putting marks next to the relevant portions of the complaint, of the ethics code that are referenced in the complaint, so that when it comes time for us to talk about them, you know where they are, and it's easier for us to find them. But first of all, the reason we're convening, the board's in receipt of a complaint stated August 21, 2018, signed by Robert Grabarski, I believe is, am I pronouncing that properly? Okay. And it alleges violations of chapter 34 of the Adams County Code, that's our ethics code, occurred, and names of the respondents as the people who did that. As I mentioned before, I was appointed, the authority is under 3410C of the Adams County Code to represent this board, and my job is really to make sure we know what we're doing, we cover the steps we're supposed to cover as we go through this hearing to make sure that we're providing proper due process as we hear the matter.
I asked Jim if I could get a copy of that.
Of
No.
the ethics code? Sure. Yeah, I have a couple extras if anybody wants them.
Thank you very much.
Sure. So we're convening an initial hearing on the complaint pursuant to 34-11. Take a look at 3411 of the code. It kind of outlines for you, I think it's sub C actually, what we're supposed to do in the initial hearing. We're supposed to convene and determine first the jurisdiction, whether we have jurisdiction to proceed, and second, whether there's a basis in the complaint to believe that there has been a violation of the code. It's a really low standard that we're looking at tonight. It's even, I would say it's even below probable cause, because later we have to determine probable cause. So it's a very cursory type of view that we take. We also have a few things that we have to review. We have to review the complaint, assuming that everything's true, by the way, today too. So taking evidence today, we could, if we need to verify something, but for the most part, we just look at the face of the complaint and say everything's true on it as we go through it today, for today's purpose. Very different if we go to a hearing, but today we just assume everything's true. I'd also want to call your attention right now to the 34-11. In determining whether we have jurisdiction, there are certain things we have to do. We have to look at the complaint to make sure it's sufficient. It has everything. And that 3411 actually lists it all. It has to be in writing. It has to state the specific provisions of the code believed to have been violated. It has to include sufficient information to support the allegations. In our case, again, a pretty low standard, but it has to have something in there. The complaint shall also include the name and address, the telephone number of the complainant, the facts constituting the alleged violation, and if there is an allegation, which we'll have to look at, there is an allegation that the complainant believes there is a conflict of interest or bias, it should actually be in the complaint as well. So that's one of the first things we have to do. That's part of our determination. We should go through each of those. I have them listed for us to determine whether we have the complaint's adequate. Then the next thing is our jurisdiction. And the jurisdiction is set forth at 3411B. So if we look at 3411B, that tells us how this thing's supposed to get to us. Okay. And what that says is the ethics board shall send notice of a copy. Notice in response to the setting of the initial hearing has to be sent out. The ethics board shall send notice, including a copy of the complaint, to the respondent 7 business days of the receipt of the complaint by the board chair. In this case, the board didn't have a chair right now. I understand you were all sent a copy? Okay. So the board chair got one. Notice shall be given via certified mail or personal service. The notice shall inform the respondent that they can file a written statement. We also have received a written statement of his or her position within 10 business days. It certainly was received within that time. The ethics board sets a time for initial hearing, since we didn't have a composed ethics board, and there is a time limit set that would be set by either the clerk or the corp counsel, in my opinion. The initial meeting shall be set within 15 days after the initial, 15 days following the 10 business day deadline. So we would have to go through and kind of, again, checklist to make sure all those things happen. All those things happen, there's absolutely no grounds for objection to our jurisdiction or competency. Also, if some of these things didn't happen, but there was actual notice on the part of the respondents, we also probably still maintain jurisdiction, although we'd have to look at the particulars if that was the case. And last but not least, we've already talked about what we're supposed to do at the initial hearing. We have to determine if there's a basis for the complaint, doing everything is true. We're going to have to check if there's, as I stated before, if the complaint has reference to a specific code provision, some explanation, how it was violated. All those things we should go through and find. With regard to how we proceed on that, as far as jurisdiction is concerned, first of all, does anybody have any questions? I know I'm just babbling along here.
No.
We also all received all the board members and I received a copy of an affidavit by Diane Hyder, attaching a bunch of documents. In case you didn't bring yours, I have copies here, and I have some extra copies if anybody would like to see it. If you could pass these down here. I think that's enough. And this affidavit, I think, covers a lot of the initial jurisdictional issues. It's pretty common procedure for a clerk or a corporation counsel, whoever has the responsibility of forwarding information in a case like this, to put together an affidavit that describes what happened. I would submit to you, reviewing this affidavit and comparing it to our list that we should make sure we were accomplished, should help us address the competency issue. And then probably want to address jurisdiction and competency. Probably want to address that first, and then we can go into the basis issue. Mr. Chairman, do you want to go through this document? Would you like me to go through it?
Yeah, if you would go through it, if we got any questions, we'll just interrupt any discussion as we go.
The document, I should mention, first of all, I think we should receive it as part of our record. It's notarized and dated September 19, 2018. Ms. Hyder says she's a legal assistant employed by Adams County Corporation Counsel. She filed a complaint with the I filed the original complaint of ethics code violation with the Office of Adams County Clerk on August 22. Apparently, it was addressed to her, or she received it. A true and correct copy of that complaint of the ethics code violation and the August 22, 2018 correspondence from the Corporation Counsel was served on the complainant and the respondents and all ethics board members. And that was done on August 22nd. Signed certified mail receipts also are attached to this. And for all the parties, for the parties. And when I say parties, I mean Mr. Grabowski and Ms. Demlo and Juan.
Your name, James?
Close enough. Is it next?
That's it, James first.
James Grabowski?
Oh, he's Robert.
Right in the front.
You're Robert. Was it in fact served on Robert?
Oh, my goodness.
Here's the first certified mail.
That's an awful cousin's playing trivia.
Well, that's a good catch. That's a good catch. We should correct the record, because I believe the certified mail request is to a Robert Grabowski, so the affidavit's internally inconsistent, but the service is in fact true. It was on Robert Grabowski, and we should make sure the record reflects that. The parties and the board are thereby notified of the ethics requirement for filing a written statement within 10 business days. Joint response by both of the respondents was filed, that's Exhibit C. Copies of the joint response were distributed to all board members. That happened on September 10th. The Adams County Ethics Board meeting agenda was posted on September 10, and an amended one was posted on September 19, and the affidavit's given in support of showing jurisdiction. I do want to address a couple other things that I was made aware of that the board might not be made aware of, might not have been made aware of. And that has to do with some concerns that were raised by the complainant. They sent a correspondence to the Corporation Council back on September 17 of 2018. They voiced concern about only receiving the board agenda. And they also stated that they wanted this in open session, which I mentioned to you previously. If they're expected to attend the ethics board hearing, they wanted to know, I see they're here. And they also thought they would like a lot of people to be witnesses. As I explained, this isn't really, we're not at that point in the process, if we get to that point. Right now, we don't call witnesses. So I just wanted to kind of address those issues. It appears there is actual notice here and participation, in fact. And in fact, the request to have it in open was considered, and we decided to go that direction. So as far as the prerequisites to jurisdiction and competency, I also want to point to the fact that the actual complaint is attached to the affidavit. Obviously, that's a part of our record, and so is the response a part of our record. So this whole document here, this affidavit, might even be a good idea for the board to accept it. I think the chair can, on behalf of the board, simply accept it as evidence. Probably a good idea to do that.
Sure, we'll accept that.
My reason for calling your attention to the complaint is we're going to be spending some time with the complaint today. We're going to have to see if it's in writing, states specific violations for jurisdiction purposes. Then we're going to have to determine the basis issues. So just kind of looking through the complaint, according to 3410, it's got to be in writing, obviously it is. It has to state specific provisions of Chapter 34 ACC of the Wisconsin statutes. And in that regard, the board should take a quick look through it. I'd call the board's attention to 7, 8, 9, and 10. Well, particularly 7, 8, and 9, that says